Judgment in the appeal to Financial Conduct Authority and Macris.
Lord Sumption will explain the decision of the court.
Mr Achilles Macris complains that the Financial Conduct Authority has served a disciplinary notice on his former employer in which it unfairly identifies him as being responsible for their malpractices. At the relevant time, Mr Macris was the International Chief Investment Officer of JP Morgan Chase Bank and the head of the bank's Chief Investment Office in London. JP Morgan was and is authorised under the Financial Services and Markets Act 2000 to carry on investment business, and Mr Macris himself was performing what are called in the Act controlled functions, which meant that he had to be approved by the Financial Conduct Authority as a suitable person to carry on those functions. In 2012, one of the larger investment portfolios managed by the Chief Investment Office began to show considerable losses. The Financial Conduct Authority has a statutory duty to investigate financial malpractice in its broadest sense and to take disciplinary action against authorised or approved persons where appropriate. It opened an investigation into the conduct of both JP Morgan and Mr Macris. After that investigation had approached its conclusion, they decided that the losses arose from a high-risk strategy, weak management, and inadequate responses to FCA inquiries. Eventually, in September 2013, a regulatory settlement was agreed with JP Morgan and a penalty imposed on them. Mr Macris did not settle until some time later, and the investigation as against him continued. The Act provides that before disciplinary action can be taken against a market practitioner, a number of notices must be served on the practitioner, warning him of the criticisms to be made and the action to be taken, including a warning notice. This is so that he may be able to make representations and, if necessary, appeal to the upper tribunal before the decision is finalised. The final notice recording the decision actually made by the authority is generally published, and publication itself serves an important regulatory purpose. Notices recording disciplinary action taken against an authorised firm like JP Morgan will almost inevitably contain criticisms of the individuals within the firm who are thought to be responsible for what went wrong. This gives rise to a problem if those individuals are either not subject to investigation or the investigation of their role is still continuing. At the time of JP Morgan's regulatory settlement with the authority, the investigation of Mr Macris's role was still continuing. Premature publication of the allegations against him would therefore have been inappropriate at that stage. The Act deals with this problem by providing that if a notice served on one person identifies a third party and is prejudicial to that party, then it must be served, a copy must be served on the third party to allow him to make representations and, if necessary, to go to the tribunal. The notices served on the bank did not refer to Mr Macris by name or by job title. They referred only to what it called CIO London Management. CIO London Management was said to have done various things that gave rise to disciplinary action against JP Morgan. But Mr Macris says that that expression was enough to identify him. This, he says, was partly because anybody who knew about how JP Morgan's business worked, and that included a fair number of people in the city, would have realised that CIO London Management in this context could only be a reference to Mr Macris. Even without that special knowledge, he adds, Mr Macris says that information available on the internet would have enabled him to be identified as the person criticised. In particular, a committee of the United States Senate had published a report into very similar matters which actually named him. The Upper Tribunal and the Court of Appeal both upheld Mr Macris's complaint, holding that in the circumstances CIO London Management would have been read as a reference to him. The Supreme Court, however, by a majority of 4-1, allows the appeal. The reasons of the majority are given in a judgment which I have prepared. In this court's view, The Act provides that a copy of the notice must be served on a third party only if the notice itself identifies him. It's not enough that he is identifiable from other sources over which the Financial Conduct Authority has no control and of which it will not necessarily have any knowledge. Not only would that be contrary to the language of the Act, but it would be difficult and in some cases impossible for the Financial Conduct Authority to deal with some persons under investigations before others, if that was enough. In this court's view, a third party is not identified in a notice served on an authorized person unless the notice itself contains enough information to identify him. That means that he must either be named or identified by some synonym such as a job title, which can only refer to him. Information available elsewhere is relevant only where it enables one to interpret the words of the notice. Thus, if the notice refers to a person by his job title, and it is possible from outside sources to discover the name of the person with that job title, then he is identified. But a person is not identified in a notice simply because there is additional material about him in the public domain, which when placed side by side with the notice shows that they are referring to the same person. CIO London management is not a sufficiently precise expression to refer to any individual, let alone to Mr Macris. The fact that people with knowledge of the inner workings of JP Morgan would know who must have been responsible within CIO London is irrelevant. So is the fact that he is identified by publicly available sources elsewhere. For these reasons, the Supreme Court will allow the present appeal.